Okay, what we've learned so far, just give me a second. What we've learned so far is, just by way of introduction, what a company is. We learned that the Companies Act is very vague with its definition of a company. It literally says a company is a company that is registered in terms of this act. So that doesn't really tell us what a company is. But then we found out that a company is a juristic person, group of people that get together and incorporate, register a juristic person, in most instances for the purposes of doing business. Sorry, I just got distracted for a moment. So the important takeaways that we had from Monday's lecture, firstly, the fact that a company is a juristic person. You've got to keep reminding yourself of this. I so often in assessments have students writing about that something went wrong, whatever, and they'll say, and he must pay. No, he mustn't pay. The company must pay, not the individuals. There are certain exceptions, but in general, it is the company that must pay, not the individuals. Secondly, we also learned that the distinctive characteristic of a company, which sets it aside from, for example, a close corporation, is the separation between management and control, of management and ownership and control. Ownership, the shareholders that own the company. Board of directors, they're in charge of the company. They manage and control the company. Now, we are going to get back to this again at a later stage. I think it's Unit 7, where we focus specifically on this. Something that I did not mention on Monday, but you need to keep this in mind as well, is a company is a creature of statute. You go back to Introduction to Law, you'll remember that in Namibia we have common law, and then we have acts of parliament, laws made by parliament. The Companies Act governs the management of companies. So there is a law that regulates how things must be done in a company. Companies Act, all studying accounting, Companies Act is an integral part of accounting and auditing as well. Please be aware that the Namibian Companies Act that we study is similar to the South African Companies Act, but there are also significant differences. I will point some of these out as I go along. Textbooks, which is why you'll see in the notes that there aren't that many textbooks prescribed, because Namibian textbooks don't exist. So textbooks that you can find will be based on the South African legislation. There are significant differences between Namibian company law and South African company law. And then please don't even think of going artificial intelligence, AI, or Googling, because that is going to give you either English or American company law, which is vastly different from ours. Having said that, let me share my screen. Thumbs up quickly if you could see the screen. Lovely. Okay, so tonight we're going to do Unit 3. You get different types of companies, all of which are governed by the Companies Act. Now, the Companies Act makes, to start off with, a distinction between, and this is this Namibian Companies Act. It's not the same in South Africa. Namibian Companies Act distinguishes between two main types of companies. And before I go on to start using my slideshow, I need you to guess. I need somebody to put their hand up or shout out. What do you think are the two main types of companies? Somebody? Daniel, I see your picture in front of me. Daniel, okay, Rushay, you've just saved Daniel. Rushay, tell me, what do you think are the two main types of companies?
Evening, ma'am. I'm just gonna take I would say a close corporation and what is the other one? Close corporation and partnerships.
Thank you for that attempt, Rushay, but no. First of all, let's go back. A partnership is not a company. A partnership is a contractual agreement. Zelda, I'm going to get your answer now. A partnership is a contractual agreement between a group of people. Paulina, give me a second. A partnership, that we learned, is not a juristic person. There is a very, very big difference between a partnership and a company. Secondly, a close corporation is also not a company. We do close corporations. A close corporation is a juristic person, but it's managed in terms of different legislation, the Close Corporations Act. Types of companies, Paulina, your hand is up, and I've had 2 reactions in the chat box as well. Let's hear what Paulina has to say.
Good evening, ma'am.
Yes, good evening. What do you think?
The two types of companies, company with share of capital and company without no share of capital.
Thank you, Paulina. Round of applause for Paulina. Let's all give Paulina a round of applause. In the chat box, I had 2 answers. 4 answers. that I was expecting. One from Zelda, one from Marilyn as well as from Ms. Kahuena, saying that the two main types of companies are public and private companies. That was the answer that I was expecting. It is, however, not the correct answer. Paulina can take over the class. She can become the lecturer. 100% Paulina. Your two main types of companies are companies that issue shares, companies with a share capital, and companies that do not issue shares, companies without a share capital. So just quickly, your learning objectives. We've already addressed the first one there, named the two basic types of companies. Those are companies with a share capital, companies that do not issue shares, companies without a share capital. Remember always to go back to your learning objectives. So your two main types of companies there, those that issue shares and those that do not have a share capital. Companies that do not have a share capital are also known as companies limited by guarantee. So you can use those two terms, company without a share capital or company limited by guarantee, interchangeably. I will clarify that in a while. Now, companies that do have a share capital are divided into two groups, namely your public companies and your private companies. The fact is that the vast majority of companies are private companies. If you had to go to BIPA, which is also responsible for the registration of companies, if you had to look at their registers, ask them, start counting the companies, you will discover that the majority of companies that are registered in Namibia are private companies. The Companies Act, however, is written from the point of view of public companies. It addresses the do's and don'ts of public companies and then makes exceptions for private companies. So it will say that, for example, a company must publish its annual financial statements. Then it will say, if it's a private company, it doesn't have to publish them. So it's written from the point of view of public companies, making exceptions then for private companies. These we will note as we go on through the semester. So looking at our organogram, you have companies, then you have companies with a share capital and companies limited by guarantee. Your companies with a share capital are private and public companies. And then there is a specific type of private company known as a Section 60B company, which we also look at in some more detail. In that regard, please note, I mentioned that companies are a creature of statute. First part of the semester, we will be studying the Companies Act, Act 28 of 2004. It is not necessary for you to memorize and remember the numbers of specific sections, unless I tell you to. This is one of them, a Section 60B company. You have to remember Section 60 brackets B. If you write Section 60 brackets C, for example, that is incorrect. Have to remember it's a Section 60B company. Why do you have to remember it? Because that's the name that we use for this specific type of company. So companies having a share. Please keep your mics switched off so that we don't get background noise. So companies having a share capital, you are all accounting students, so you should understand this. Companies with a share capital obtain their capital by way of issuing shares in not the next unit, not in unit 4, in unit 5, we end up taking a closer look at share capital and the different types of share capital. So these companies obtain their capital by issuing shares. That's where the concept of companies came from about 200 years ago. We looked at the Solomon versus Solomon and Company case on Monday, and we saw it was almost 200 years. That judgment was passed about almost 200 years ago. That's how old companies are. Now, the whole concept of a company arose 200 years ago from the principle that you need money to make money. In order to make money, you need money. So a budding entrepreneur that wanted to start a business but didn't have money to start this business would register a company and then invite friends, family, investors, whatever, to buy shares in this company. This money that they paid for the shares would then be his startup capital to get the business going. But of course, a person that invests in somebody else's business idea also doesn't want to be reckless, and they want to protect themselves. Hence, a company was a good vehicle for this because the company is a juristic person, which means that if this business idea doesn't work, if it all goes pear-shaped, the only risk that these investors took was the amount that they originally invested, the amount paid by them for their shares. So business goes pear-shaped. If you've invested $100 to buy shares, business doesn't work, it goes bankrupt, you're going to lose your $100. But at least you're not going to be held liable for any additional business debts that have been incurred. So that's where the whole idea originated. Companies obtain share capital by issuing shares. And in most instances, members, shareholders stand to lose no more than the amount paid for them by their shares. These companies are then divided into public and private companies, as I have already mentioned. Requirements for the existence of a public company. In order to have a public company, it must have at least 7 shareholders. You cannot register a public company if you don't have at least 6 other buddies that are going to register and sign the founding documents with you. At least 7, no maximum, can be hundreds, no restriction on the numbers. The name of a public company ends with the word limited, or abbreviated as LTD. Now, I've got to warn you that you have to be able to recognize the names of the different types of companies. You need to be able to identify in a case study. In a case study, if the company I'm referring to is, for example, described in the case study as Zelda Limited, then you must immediately know that this is a public company. As I've explained, Companies Act refers primarily to public companies, makes exceptions for private companies. There are certain instances where I can ask you a question based on a case study where the answer that you're going to give is going to be different, whether the company in the case study is a public company or a private company. Now, in my case studies, I'm only going to say Zelda Limited, blah, 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 and whatever the rest of the sob story is. I'm not going to say Zelda Limited, which is a public company. But when you read your case study, you must make a mental note. Okay, this is a public company, so that is what the correct answer is going to be. Always be aware of what type of company the question, the case study is referring to. Characteristics of a public company is that anybody, any member of the public is allowed to purchase shares in a public company. There's no limitation as to who may or who may not own shares in a public company. These shares are also freely transferable. If I've got shares in a public company and I don't want them anymore, I can sell them to anybody else without having to get permission. They are freely transferable. Skipping to the last bullet point, shares and debentures may be listed and dealt with on a stock exchange. Please note, may be listed, not must be listed. It is optional. It's totally optional whether the company is listed or not. But in order to be listed, it has to be a public company. You cannot list a private company. Stock exchange, that is where people buy and sell shares in companies. Any members of the company, and these shares are freely transferable. You can buy them when you want, you can sell them when you want. Now, because of this public trading in shares, it is, of course, very important to protect your shareholders. Going back to the separation of ownership and control. If I have shares in a public listed company, or any public company, not even necessarily a listed company, if I'm a shareholder in a public company, I am a part owner of this company. But the board of directors are the ones that are managing my property. And that's the whole purpose behind the Companies Act, or one of the purposes behind the Companies Act, is to protect the owners against potential abuse by the directors. Hence the requirement there. Companies Act contains extensive provisions, comprehensive provisions regarding the compulsory disclosure of information concerning the company, publishing annual financial statements, etc., etc. Purpose behind this is to protect the public shareholders and the public against abuse of power, mismanagement by the board of directors. If I'm going too fast, please, I'm focusing on my screen that has the PowerPoints, not on my actual Teams class. As was the case last semester, if you don't understand something or you have a question, please just shout out and I'll stop immediately. Private companies. First of all, only companies with a share capital can be private companies. You cannot have a company limited by guarantee as a private company. Only companies with a share capital are private companies.
Good evening, ma'am. Before you carry on, Brezhnev here. Good evening, everyone.
Yes, Brezhnev.
Before we carry on, maybe I'm just jumping the gun here, but on the private companies are the only ones with share. What about the public share companies that have public shares then also?
Thanks for interrupting, Brezhnev. Maybe I didn't completely explain this correctly. I did not say that public companies may not be companies with shares. Let's go back to this slide.
Okay.
Let's go back to this slide.
Right.
You've got companies with a share capital that can be either private companies or public companies. So definitely public companies issue shares. Listed companies, that's the whole point of the stock exchange, the free exchange of shares. So companies with a share capital are both private companies and public companies. But in order to be a company by limited by guarantee is also a public company. In order to be a private company, it must have a share capital. But that's not implying that all companies with a share capital are private companies, if you follow what I mean.
Okay. I get what you're saying now.
Are you with me now? Okay.
Slightly. I'm just trying to make sense of it, but I'm getting there. Okay, but we can carry on. I'll ask questions after class also.
Okay, let's carry on then for the meantime, but don't be confused. Your company at the moment, I'm talking about, I started off by telling you get these two main types of companies. But at the moment, I'm focusing only on companies with a share capital. So that bit here, companies with a share capital. We'll get to companies limited by guarantee later this evening still. At the moment, I'm talking about companies with a share capital. Companies with a share capital are private companies and public companies. A public company can either have a share capital or it can be limited by guarantee. A private company must have a share capital. Is that more clear? Let's carry on. Hopefully it becomes more clear as I carry on. So private companies, the name ends, how do you recognize it? It's a PTY. Limited. So in a case study, if you see the name of the company followed by the abbreviation PTY Limited, you know this is a private company. How many members must a private company have? Now, this is a strange provision in the Companies Act. Companies Act says that a private company must have at least 2 shareholders But then it carries on to say, unless it is a company with a single shareholder. It's one of those oddities of the Companies Act. It literally says you must have 2 shareholders, but it's okay only to have 1. So what is the minimum number of shareholders required? Actually, only 1. But if in a test I ask you that and you write 2, I'll give you a mark for 2 as well. These private companies, because they are smaller, the separation between ownership and control is not that big, is not that obvious. In most private companies, your shareholders are actually also your directors. So they are, this is where the Companies Act makes exceptions for private companies. Private companies are excluded, exempted from some of the strict disclosure requirements expected of public companies. They don't have such strict rules. Now, in order for a company to qualify as a private company, there are 3 provisions that must be included in its constitution. Now, right now, you don't know what the constitution of a company is yet, because you're only going to learn that next week and Monday. It's one of the things that makes the first couple of weeks of company law a little bit confusing, is terminology that I'm going to be using, terminology that I haven't explained yet. But I had to start somewhere. Now, every company has a constitution, its rules in terms of which this company is to be managed. And in order for a company to be a private company, the following 3 provisions must be included in these rules. First of all, this is the easy one. It's the middle bullet point. Maximum number of members is 50. And it must state in its constitution expressly that the maximum number of shareholders permitted is 50. So what is the membership of a private company? From 1 person, minimum 1 person, maximum 50. Then it must contain in its constitution, in its governing rules, some restriction on the right for the free transferability of its shares. If we go back, public companies, shares are freely transferable. Private companies, they are not. In its constitution, there must be some provision which restricts, which limits the right of its shareholders to freely transfer its shares to anybody else. The Companies Act does not prescribe the content of this limitation, this restriction. That is up to the founders of the company to decide for themselves how they're going to word it. Some examples of restrictions that you could find in constitutions of private companies, for example, is that shares may only be transferred with a consent, with the permission of the board of directors. Or if you want to sell your shares, you must first offer it to the other existing shareholders. Anything that limits in some way your right to freely sell and transfer your shares to anybody else. So you cannot just randomly sell your shares without following the rules. And thirdly, the third requirement, which makes it a private company, is required for a private company, is a prohibition on offers to the public to the subscription of its shares or debentures. A private company, a public company can at any time offer, if it wants to raise more capital, It can advertise and say, we are selling shares. If you've got money, come and buy these shares. A private company may not do that. But don't misunderstand this. This does not mean that you may never sell your shares in a private company to somebody else. Don't take the definition of members of the public too wide. Let's say, for example, Brezhnev, Zelda, and Evelina are the three shareholders of a private company. But they know Naimi, they know she can contribute to the company, she's got skills that they might want, etc., etc. They are welcome. This prohibition of offers to shares to the public does not mean that only the three of them will forever be the shareholders. They are welcome to approach Naimi and say, listen, do you want to join us? Buy some shares, become a shareholder. That is not what this prohibition means. The prohibition means you may not advertise randomly to the public. So Brezhnev, Zelda, and Evelina cannot place an advertisement on Facebook saying, come and buy shares in our company. But they can absolutely approach Naimi and say, become a shareholder. Everybody with me? Brezhnev, are you with me?
I'm 100% listening, ma'am. I have few questions, but I'm listening. Probably I'm just jumping because I don't have additional notes that I have to read ahead. But okay.
Okay, well, remember those questions? Once I've gone through my slides, then we can have a conversation as well. If I haven't answered your questions yet, I'll try to answer them. Okay, so that's what private companies are. A company, maximum 50 shareholders, containing in its articles, its constitution, these requirements, a restriction on the right for the free transferability of shares, limitation on its number of members, and a prohibition on offers to the public for the subscription of its shares and debentures. Now, a Section 60B company is a specific type. Let's go back here. We've looked at public companies, we've looked at private companies. A Section 60B company is a specific type of company, a private company. It will always be a private company. A public company cannot be a Section 60B company. Section 60B companies are your professional companies. Primarily legal practitioners. There are certain professions that allow, okay, let's take this from a different point of view. Firstly, how do you recognize them? The name will end in incorporated or the abbreviations INC, Inc., instead of Pty Limited. So if it's Gontep Inc., then we know this is a Section 60B company. The reason behind these companies is there are certain professions, specifically that the Legal Practitioners Act, which requires that members of this profession cannot escape liability for the debts of their business. And of course, the whole purpose behind a company is the fact that it's a juristic person. But the fact that it's a juristic person is not the only advantage of a company. There are other advantages as well, certain tax advantages, as well as the advantage of perpetual succession, etc., etc. So sometimes people are practicing as a lawyer, as a legal practitioner, and they want to have these advantages of being registered as a company. But in terms of their founding professional legislation, the Legal Practitioners Act, they cannot escape the debts. That would be illegal for them. Section 60 or Section 60B of the Companies Act makes it possible for certain professions to, in fact, have the best of both worlds, where they can register as a company, but in terms of Section 60B of the Act, the constitution of the company provides that directors and former directors of this company can be held and will be jointly and severally liable for the debts of the company, debts and liabilities of the company, which were contracted during their period of office. What does that mean? What does this liable for the debts of the company that were contracted during their periods of office? What does that mean? Let's illustrate that quickly. Let's say this is 3 legal practitioners registered as a company, Section 60B company, Hontep Incorporated. Brezhnev, Zelda, and Evelina are the 3 shareholders and the 3 directors. In January 2025, Naomi joins them and becomes a shareholder and a director. Naomi will not be liable for any debts incurred before she became a director. So anything prior to January 2025, Naomi is not liable for. In July 1995, Naomi resigns and goes elsewhere. Her liability for debts incurred between January 2025 and July 2025 remains, even if she's no longer a director. Resigning as a director is not an escape clause, but anything incurred after that, so in August or September, she will not be liable for. Directors of these types of companies are liable for any debt incurred by the company during the time that they were a director. And they remain so liable even if they have stopped being a director. So that liability doesn't suddenly disappear if you stop being a director. Which debts am I talking about? It's not all the debts of the company, but only contractual debts and liabilities, debts that arise from a contract. It does not include delictual liability, so debts incurred, damages have payable in terms of a delict, or a statutory liability. A statutory liability would be something like income tax, a liability which arises by virtue of an act of parliament. It's joint and several liability. Sure, you remember the concept of joint and several liability dating back to your studies of partnership last semester. So a creditor can hold, anyone can hold the company and any one of the directors or all the directors together liable. A director who has paid any of these debts will be able to claim their proportionate share back from the other directors. Questions before I carry on with the other type of companies without a shareholding? None so far. Okay, a company limited by guarantee. All companies limited by guarantee are public companies. You do not get, as I've said previously, you cannot get a private company that is limited by guarantee. In order to be a company limited by guarantee, it must be a public company. Because it's a public company, you need at least 7 persons in order to register it. Now, what is unique to a company limited by guarantee? If we go back to public companies, so I'm just looking for the companies having a share capital, sorry, this slide. These companies obtain their capital by way of issuing shares, and members stand to lose no more than the amount paid for them by shares. And as I explained, historically, this money that they paid for their shares was the starting capital of the company. A company limited by guarantee, they don't have a share capital. People don't buy shares. Instead of buying shares, in their constitution, in the memorandum, they undertake, all the members undertake that if the company is wound up, if the company is liquidated, they undertake in the memorandum to contribute a certain amount towards any outstanding liabilities of the company. This provision is actually purely theoretical. Companies Act says that they must undertake in the memorandum which they sign, they must undertake to contribute amount which may not be less than $1 Namibia per member, which they will pay into the kitty to help settle the debts of the company once it is wound up. Now, it doesn't say it must be at least whatever. It says it mustn't be less than $1. So what happens when people register these companies, that all the 7 members agree upon winding up to contribute $1, which gives us a total of $7, which is obviously not going to go very far in paying the liabilities of the company. But they can't be held liable for more than that, because the company is still a juristic person. So that's really a pretty toothless provision. It's a company, it's a public company. All the provisions that pertain to public companies apply to these companies limited by guarantee, including the compulsory disclosure provisions like lodging annual financial statements, etc., etc. How do you recognize them? The name will end in limited and then followed in brackets with a statement limited by guarantee. Although the Companies Act does not prescribe that these companies may not be used for business purposes. It very, very rarely happens that if somebody registers a company for the purpose of a profit-making business, that they will register a company limited by guarantee. Rather, they will go the route of registering a company with a share capital. So why do we have these companies? Because of a very specific type of company, namely your non-profit association. Section 21 of the Companies Act, you have to remember Section 21 as well. So two things already to remember from today's lecture: 60B you've got to remember, and 21 you've got to remember. Non-profit associations, your Section 21 companies, are companies limited by guarantee. They don't have shareholders, they have members. How will you recognize them? Because the name ends in non-profit association incorporated under Section 21. Common parlance, they're known either as Section 21 companies or non-profits. Any other company, a private company or a public company with a shareholding, Companies Act provides for certain procedures to be followed, and they can convert from one type of company to another type of company. Any company can be converted to a non-profit, but the Act specifically and expressly prohibits the conversion of a non-profit into a company with a share capital. There are specific reasons for this. What makes a non-profit association? First of all, its main profit must be the promotion of religion, arts, sciences, some charity. And any profits that it makes, and don't get confused here. If I'm saying this is a non-profit association, I'm not meaning it may not make a profit. Not saying it may not do business. It may absolutely make a profit. It may absolutely do business. But whatever profits it makes must be plowed back into promoting its main object. Take a private school, for example. Many private schools are registered as a non-profit association, Section 21 company. They are allowed to charge school fees. And some of these private schools charge hair-raising school fees. And of course, they're allowed to pay salaries. They're allowed to pay their teachers, etc., etc. But whatever profit it makes at the end of the day may not go into the personal pocket of the members. It must be plowed back. Companies Act prohibits the payment of dividends to the members of a non-profit association. This must also be contained in the memorandum in the Constitution, that income and property shall be applied solely towards the promotion of its main object. So whatever its main object is, no portion shall be paid to the members. That does not mean the shareholders cannot earn a salary for a job done, but they cannot share in the profit purely because there is profit sharing. And to make sure that people don't get in a lot of donations, whatever, and decide, let's close this company down and put this in our own bank account. At the end of the company, upon winding up deregistration or dissolution, whatever remaining assets it has must be transferred to a similar association with the same object. That is why a non-profit association cannot be legally converted to a company with a share capital, is to prevent abuse. That somebody has registered a non-profit and it's gotten in a lot of foreign donations. People have been giving to this good cause. And then the members get greedy and decide, okay, let's change it to a private company and take this money for ourselves. Questions? Silence. Okay, our last slide. You also get external companies. What are external companies? External companies are companies that are not registered in Namibia. Company that is registered in a different company, South Africa, Angola, Botswana, wherever, when they establish a place of business in Namibia or engage in a transaction in Namibia, they don't have to re-register in Namibia. They can remain registered in their country of origin, and they will be known then as an external company. How do you recognize them? Because the name ends in incorporated in whatever country they are registered in. That's it. Lots of information today. Company law gets better. I know at the moment it all sounds like a very great big muddle. Don't despair. It gets easier as soon as you start understanding the underlying concepts. Brezhnev, your questions? Or do you need to think? Yes, Brezhnev.
Is it possible then, after class, maybe then I can ask you on the group or something? I just don't want to now ask. Then I have some of my colleagues from the class also confused because just probably certain things I just want to ask.
Brezhnev, please do. Please do. If you'd rather sort of spend a little bit of time working through your own thoughts to sort of figure out what you understand and what you don't understand, please do ask on the group.
Yeah, no. I want to ask on before, whilst if people leave or after the class, then I wanted to ask, not to confuse people on what we have taken in. It was quite a mouthful, really. Interesting though. So I just wanted to ask just, I think 3 points or 2, just a little bit clarity amongst that.
Okay, Paulina had her name up. Let's give Paulina an opportunity.
All right,
Paulina,
thanks.
you had your hand up. Paulina? Okay, well, that's my lecture for this evening. You're welcome to log out. I'll give Brezhnev then the opportunity to, you're welcome. Okay, Paulina, your hand is up.
Miss, I wanted to find out about us that have just registered from yesterday. Are we supposed to enroll ourselves on e-learning, and how are you gonna add us on MS Teams?
Sorry. The student support officers will continue adding students as the new registrations come in. I will also open e-learning for self-registration, self-enrollment, and send you the link. I haven't done it yet.
Okay,
But
ma'am.
yeah, but otherwise, the student support officers continuously add students.
Okay, miss. Thank you.
Okay. Thank you, Paulina. Rushay?
Ma'am, I also wanted to find out, I dropped it in the chat, but I don't think whether you saw it. Is there perhaps a study guide for the module, or is it the same as Introduction to Law for Accountants, where it's just a soft copy of all the slides that we are going to go through, or do you have a copy, like a study guide copy?
There is actually, I don't know, I still need to find out whether they have them in supply at the printers at the moment. If not, I will have them printed again. But for company law, there is actually a hard copy study guide available. So I'll just double check whether they've got copies at the moment. Otherwise, all the notes are also available on e-learning, as was the case for Introduction to Law. But company law, there is actually, I do have hard copies printed as well. As soon as I've figured out whether they have and had more printed, I will let you know.
Thank you, ma'am.
Okay, well, you're welcome to leave if you're afraid that Mr. Gontep's questions might confuse you. Otherwise, you can obviously listen to us as well. Brezhnev, over to you. What is concerning you? Let's see if I can clarify some issues for you.
Okay, in the case, currently I don't have any, or I did not go onto the e-learning to check on the, what you call this, the learning material. But I was listening to the class that you gave today about the public and the public and private companies. But I was just because in real life simulation, I was faced with this, being one of the people working in the bank, and I I actually had a real life experience of having to open an account for one of these institutions. So I just wanted to know what is where does the parastatals fall into this? Uh, because you find parastatals that are public end and you find them that are private, or is it just a notion that I'm having? Because the constitutions also that they have provided me with in the section 55 and all of them, when I'm checking through the notes that you gave us, I'm actually seeing that probably I made a boo-boo somewhere, but okay, we live and we learn. So I did not actually.
But Mr. Gontep, this is a very, very interesting question that you're
Mhm.
asking. Um, and I'm glad that you are already, and this is why I enjoy teaching company law so much, because now already it's only our second lecture, and already there's a student who's employed, who has a wider world vision, more experience, starting to sort of query, but hang on, she just said this, but this is what I'm experiencing or what I'm dealing with at work. So how does it all fit together? And that's what I love about company law. Now, your parastatals, and first of all, you shouldn't use the word parastatal. You call them
Okay,
state-owned enterprises.
okay, okay.
You get very many different types of state-owned enterprises. They don't all fall under one category. If you take the Roads Authority, for example, the Roads Authority, and remember in Monday's lecture, when we spoke about how does an association acquire legal personality, how does it become a juristic person? And one of the ways is by way of founding legislation. So you get the Roads Authority, which was established in terms of the Roads Authority Act.
Mhm.
It's a juristic person, but it's not a company in terms of the meaning of the Companies Act. It's a juristic person, but it's not a company.
Can
A
you
company,
because now I'm now lost. I'm quickly lost now. You're saying just on what you said, they're not a juristic. But
they are. No, they are. It's a juristic person.
uh-huh.
It's a juristic person. But not
Mm-hmm.
all juristic persons are companies in the sense of a limited or a PTY limited.
Uh-huh.
The Roads Authority is just the Roads Authority of Namibia. It's not Roads Authority of Namibia Limited. So it's a juristic person, and it has its own constitution and act and everything. But it's not a
Ma'am, I might have lost.
company.
Okay, okay.
It's not a company. But then you
Okay.
also get companies that are registered in terms of the Companies Act, which are state-owned enterprises. August 26 Limited.
Yeah.
Yeah,
That's a owned, I think that's state-owned, August 26. Soldiers to someone, the NDF. I think most of them are there. But August 26.
yeah. August 26 Limited is a company. It was literally registered in terms of the Companies Act. In
Mm-hmm.
fact, many, many years ago, I was the person that registered the company that was in charge. I was working for the government attorney. And as part of my job there, I attended to the registration of this company known as August 26 Limited. But it's a state-owned enterprise because all the shareholders or the sole shareholder is the government of Namibia.
Mm-hmm.
You even get other companies like MTC, for example, where
MTC.
it's a company registered in terms of the Companies Act. But the shareholders are government in Namibia and even some other investors or important entities as well. So in the biggest picture of state-owned enterprises, there's a lot of variation to be found.
Okay, so the law that's governing them basically is still the same, pertaining to what the act is on, whether it's a public or private company, or is it does it vary because
No, if it was a
it is like action?
if it was a company that is
Mm-hmm.
registered in terms of the Companies Act, so its name
Mm-hmm.
ends in limited or PTY limited, the provisions of the Companies Act applies to that company, irrespective of whether the government is the sole shareholder or not. The fact that the government is the shareholder does not mean that the Companies Act can be ignored. The Companies Act still applies to it.
So the government can have a PTY also.
Government can absolutely have a PTY where it's the shareholder of a PTY. There are a number of them.
Okay.
There's nothing legally prohibiting the government from registering a private company with the government of Namibia being the shareholder of this company. It happens. It's perfectly legal. That company will then resort under the Companies Act, and the provisions of the Companies Act will apply equally to that company as it does to any other company.
Okay, okay. I hear you, ma'am. I hear you. Okay. Coming back to my second question that I had was there was something that you mentioned that in an incorporation that uh, a, a a partner or a member that joins is not liable for the debt before, but because how I tried to understand it was like, is it like an ANC contract, like ANC with accrual and ANC not with accrual? Like when you're joining the PTY under the section 50,
60,
50,
60.
56,
No,
60,
section 60, section 60B,
60,
section 60B.
60.
Remember that?
60
Yeah,
B.
yeah,
Oh,
60B.
60 B.
Yeah,
Okay, so under that section, it's like when you were mentioning when somebody joins the company under the non-profit, they are not liable for the debt after the contractual agreement was done, but they are liable for the debt when the contractual agreement was there. I just kind of sounds like the ANC contract, like when the marriage contract. I'm sorry now that I'm taking a little bit vague, but just to understand the
yes,
concept.
yes. It's the first time I've heard anybody making that comparison, but thinking about it, yes, you can. You can make it, it is similar, it is comparable.
Okay, okay, okay. Because after accrual is like everything that you have obtained after signing the contract, then everything after that, and thereof you are liable
Yes,
until new agreement is done, and then before that, then you're not. Even
yes,
if you have entered.
100%.
Oh, okay.
Yes,
No, no. Now,
100%.
okay, I get a little bit clarity on that. Oh, okay. My apologies once again. I'm just because in real time, then I've been faced with this before also. So there is some boo-boos that I've made, and I'm like, oh, probably I did not know my ex too
Mm.
correctly, but I was put into, and I was not forced into, but I was placed in a position where I had to just read and try to understand what it meant and go forth. But now it makes a little bit light of it all because especially when you have to explain it to somebody. I'm still trying to get my finger around everything
Mm.
else, but I think I'm getting a little bit what you were saying.
Yeah. Mr. Conte, what I'm going to do, somewhere right now after this class, because I
Mhm.
know not all of you have access to e-learning yet. I am going to share the notes of Unit 3.
Okay.
It might be useful for you after my lecture now, when you have time to read through the notes. It
Okay.
might, because my PowerPoint slides are very much just keywords, whereas the notes themselves contain a bit more explanation. So
Oh, okay.
maybe if you've got some confusion in your mind at the moment, actually, I just sort of solidify your thoughts. So that will be useful for everybody.
And asking, if I say, also probably self- I think uh,
It's 100%. Units 1,
probably
for you, for everybody. Thank you so much. Have a
Have a
lovely evening further.
Okay, and everyone else.
Bye.
Bye.